right, then I think we can start with the next conference. Welcome everyone, and thank you, Ronan, for having me today. I'm happy to provide today to you an overview of the AI Act requirements and the data protection requirements we have within GDPR. My name is Stefanie. I'm the Deputy Head of Data Protection for ePrivacy. ePrivacy is the external data protection officer of InnoCraft of Matomo. And we are a data protection consulting and certification company. So what are we going to have a look at today? So we're going to do this overview on an example, on a use case that I have today here with you. It is about customer journey optimization with AI. And then we're going to have a look at the AI Act and give you an overview of for who the AI Act applies to. And then we're going to talk about the GDPR requirements that there are for AI systems. And last but not least, we have some top 5 to-dos for you that work for deployers of AI systems. Now, of course, I need to mention this does not replace legal advice. We're here to serve an overview and an introduction into the regulation of AI. So we're going to start with our use case. This is a use case about customer journey optimization. So as an example, we have an online retailer that uses Matomo Analytics on their website for traffic monitoring, campaign tracking, and product recommendations. And the site doesn't have any user accounts, but it collects the visitor IDs, hashed IP addresses, and of course the interactions of the website users with the website. And then the use case is that this retailer runs AI algorithms on the raw data export to analyze, for example, abandoned patterns or optimal times to send campaign promotions based on these visiting patterns of the website visitors. So what do we have to look at when we talk about the AI Act? So first of all, the AI Act deals with AI systems and artificial intelligence. And first we need to have a look at, okay, what is defined as an AI system by the AI Act. And here it is defined as a system, a machine-based system that operates with varying levels of autonomy for explicit or implicit objectives to generate outputs such as predictions, contents, recommendations, decisions that then influences the environment. So this is actually a quite broad definition of AI systems, especially regarding the varying levels of autonomy. With this definition, like simple software models are excluded, but it is not a precise distinction between, okay, where do we have only software models and where do AI systems start? So it is not quite clear to what extent a machine must work without human intervention, and it's not clear what is the minimum level of autonomy that a system must have to fall under this definition. So if we are using AI systems or we are dealing with AI systems, then there are different operators mentioned in the AI Act who have different requirements and they're responsible for different requirements. And here it is really important that depending on the use case, there can be several roles a company can take on. So here are basically the 4 operators that there are. So the most frequently one and the ones who have the most requirements are the providers and the deployers of AI systems. So providers of AI systems are companies that develop or have developed an AI system, and they bring it onto the market under their own name. So for example, a company that develops an AI system that is then used for the analytics. Then on the other hand, we have the deployer, and the deployer is the company that then uses this AI system under their own responsibility. So for example, the online retailer who might use an AI system to run it over their analytics data set. This would be then a classical deployer under the AI Act. If this online retailer now maybe has developed an own AI system that they run over their analytics, then they could be even a provider and a deployer. So we really need to have a look at the case and the use of AI systems to see which operators we are. But from a further for the next slides today, we are going to have a look for this use case as the online retailer as a deployer. So someone who uses an AI system from an external provider. Yeah, and the other two operators, the distributor and the importer, are basically operators that are between the provider and deployer, but they don't have that much requirements. So we concentrate now on provider and deployer. Yeah, so the AI Act has entered into force in August this year, but right now there are not all requirements need to be fulfilled right now. There are some deadlines on when we need to implement the requirements. First deadline will be in February next year, which will be for the prohibited AI practices that there are under the AI Act. And about building AI literacy within a company. And then we have further deadlines for the requirements for general purpose AI models and for the high risk AI systems, which will come later on. But what is important to already prepare now for these requirements, as especially for general purpose AI models and for high risk AI systems, the requirements are extensive and we have a lot of requirements we need to implement, and so it makes sense to already now to deal with these requirements to prepare as good as possible. So the AI Act follows a risk approach, just like the GDPR. So on the top, we have the unacceptable risk for AI Act, and these are the prohibited AI practices. So the practices that we are not allowed to perform anymore. And this will start from February on next year, where we need to stop using these prohibited AI practices. What they are, we're going to have them listed on the next slide. But then we also have high-risk AI systems, and they have the most requirements that need to be fulfilled under AI Act. Then there are the systems that have a limited risk. There are only a few transparency obligations under AI Act that apply for just certain AI systems, for example, for chatbots or for using and creating deep fakes. And then basically there is, just roughly explained, a transparency obligation to mark these as created by AI, or the example of chatbots, that they are marked that you're communicating with a chatbot and not with a human person. Then we have the systems that are classified as low risk, and they just have very low requirements under the AI Act. And these are, for example, spam filters. Then next to the four risk categories for the AI Act, we have the general purpose AI models. And these have separate requirements in the AI Act. So general purpose AI models are basically models that can be used for various applications and for various cases. A typical example, this is also what the government had in mind when creating the AI Act, is ChatGPT-4, because it has different cases for which it can be used. So it can be used for text generation, for translation, for question to answering questions, and so on. So there are different use cases. And basically, these general purpose AI models can fall under all four risk categories, depending on what it is used for. And that's why the AI Act contains special regulations that the developers must already observe for the general purpose AI. Yeah, so what are the prohibited AI practices that there are? So to these are behavioral manipulation and exploitation of weaknesses and vulnerabilities. Then there is social scoring, but only if it leads to an unjustified discrimination of people. Then we have predictions of criminal activities. Then the creation of facial recognition databases, for example, by reading images from the internet, or by reading out surveillance cameras. So this is also prohibited use. Then there is emotion recognition in the workplace or in educational institution. There is also an exemption if the emotion recognition is used for medical or safety reasons, then there is an exemption under AI Act. Then we have biometric monitoring for law enforcement purposes, and biometric categorization to draw conclusion about sensitive data. So if we come back to our use case about the AI system that is used to analyze our tracking data, then if we have a look at these prohibited cases, probably it will not fall under it. But of course, it depends on if we have what kind of data we have included. But in a basic case, this will not be biometric data, so we would not have biometric categorization. So in a general use case with that, we will not fall under this, but this will need to be checked. Then we have the high-risk AI systems. And these, as I said, have the most requirements under the AI Act, and these include systems from the areas of biometrics, critical infrastructures, so for example, for water or gas or electricity. Then the area of education. Then we have employment and HR management. This is typically one area that applies for a lot of companies, as AI systems might be used within the HR department. But in our use case, this also does not apply. There are two more examples: services and social benefits. For example, for healthcare or banking sector, and systems that are used for law enforcement, administration of justice, and border management. So as you can see, these are all areas that have a higher risk in the use. So with a basic analytics data that we have from website visitors, we would not fall under these high-risk AI systems. But we need to carefully check if we do, but for basic use, this will probably not be the case. Yeah, then besides the categories, the risk categories that we have and the requirements that apply depending on the risk category, we have one requirement that applies to all providers and deployers of AI systems, which is to develop AI literacy within the company. And this is then basically if you are a company who uses an AI system for their tracking data, to analyze the tracking data, then this is a requirement that you will fall under, that you need to implement. And so you need to ensure that all your employees who are working with the AI system, that they have a sufficient level of AI competence. Yeah, and this might include a technical knowledge of the AI system, a knowledge of legal requirements, so that they know to look out for GDPR requirements and also for the AI Act requirements, and knowledge about general compliance for risk assessments and for the implementation of the legal requirements. Yeah, and of course, not every employee who works with AI system needs the same level of knowledge from AI system. Yeah, so we need to have a look, okay, who is working to what extent with AI systems, and then decide, yeah, what kind of level is sufficient for them to work with the AI systems, and yeah, that we are within the legal requirements. So what are there for risk mitigation measures for the AI Act? So the first one is, of course, to check if we are compliant with the prohibited AI practices, so that we don't use them anymore starting from February next year. Then we should check whether we are using a high-risk AI system or a general purpose AI model. Yeah, because these have a lot of requirements we need to take care of under AI Act. And then we should also check whether we fall under the transparency regulation for the specific AI systems like chatbots or the creation of deepfakes. And the next one, as we just had, to build AI competence within the company, so that all employees who are using the AI systems know how to use them properly within the legal frameworks. Yeah, and this can be done by training of the employees, but also with internal policies and guidelines. So there could be, for example, with our use case, an internal policy for employees who are using the AI system to analyze the tracking data, so that they know what they are allowed to do with the system, and how to use them within the legal framework. Then next to the AI Act, we still have the GDPR, which needs to be taken care of additionally. So the AI Act does not contain requirements for processing of personal data. It refers to the GDPR that it needs to be considered when we are processing personal data. So when do we need to take care of GDPR and comply with the requirements? As said, GDPR applies to the processing of personal data. So what we need to do is to check with our database that we will transfer into the AI system for the analytics, we need to check if personal data is involved in this data set. And if it is, then we fall under the scope of GDPR. And here it is important that we, on the one hand, check whether sensitive data is involved. Sensitive data includes the origin of people, political opinions, religion, biometric data, genetic data, health data, and data on sexual orientation. Because this data requires a higher standard of protection under GDPR, and often we need consent to process this kind of data. And then it is also important to have a closer look at the definition of personal data, because most of the time many people think, yeah, of course, the name and email address is personal data, but there is also other data that is considered as personal data if we can make an identification through this data. So, for example, if we switch the name and the email address with an unique identifier, then this is considered as personal data because at some point or a third party might have a list that connects the identifier again with this person. And if there is a way to make a connection to a natural person, then it is considered as personal data. And this is called pseudonymous data. So this is very important that we really closely check, are we or is personal data included in the data set that we want to put into the AI system. And then on the other hand, there is anonymous data. This is not classified as personal data. So if we only process anonymous data, then we do not need to take care about the GDPR requirements for this data set. But here it is important to give an example of anonymous data. This is only aggregated statistical data or target groups and segments, but there are no, for example, unique identifiers included, but only rough data about, okay, maybe how many men and women visited the website, or from which country did the website user visited our site, but it is not regarding an individual person and has no unique identifier. Yeah, as an example, to have a look at what phases of the AI system the processing of personal data can be relevant. I have here, a simplified graphic of an AI system. So in the middle, we have here an AI model that is being used for our purpose. So for the analysis of our analytics data set from the website. And this AI model, if we use it from a third party provider, they have initially trained this AI model with the training data set, so that the AI model is functioning and knows what to do. And then this model is integrated in an AI system. And the system has two user interfaces, the ones for the inputs and the one for the outputs. The input is then would be our data set, our analytics data set from the website that we would put into the AI system and ask it to analyze our website visitors data. Then often within AI systems there are filters. This might not be the case here, but it could be that there's some data that will be filtered out by the AI system. And then there will be a preparation phase where the AI system makes the inputs understandable for the AI model. And in an example from a chatbot that we always also have, they break down the inputs, the sentences that we put into the AI systems into tokens and convert them into numerical numbers. And so it is readable for the AI model. It can process the information and prepare the answers, the outputs. And sometimes it can be the case that before the AI system gets out the outputs, that in a follow-up phase, the information or the data will be enriched with information maybe from the internet or from other databases. So this is something that could happen, but it depends on the AI system. And then we get the outputs of our system. So the analytics that we want, or the predictions from our website users. And this is then often used for post-training for the AI model, so that the AI model learns from this kind of data set and can use it for further improvement. And then also the outputs, of course, then are further processed by the user. So maybe further processed by you, because you will take the analytics and predictions that you received, and you might further process these. Yeah, so this is the basic setup. So if we now think about where can be a personal data processed, this can actually be nearly every phase. So we really need to have a look at every single phase and see, is personal data involved here? And then for these individual phases, have a look at the GDPR requirements that we need to fulfill for each of these phases and purposes. There is currently one discussion about whether the AI model itself is processing personal data, because the Data Protection Authority in Hamburg in Germany has published a discussion paper, and there they claim that the LLM, the AI model, does not store personal data. And they claim this due to this setup that within the preparation phase in the AI system, the data, the sentences are breaking down into tokens and numeric values, and they say that this is no longer personal data. However, this has been discussed a lot within the data protection bubble, and there are other opinions that say, no, this is still personal data, and we need to apply GDPR for the AI model itself. To give you an example why they argue that way, if you just have the AI model, and the AI model has been trained with a data set, it could be the case that when you are putting an input into the AI model, that something from the training data set will appear in the outputs of the AI system. And this actually shows that the AI model itself must store personal data or data. And if it wouldn't store any personal data or process personal data, then the training data set wouldn't actually appear in any outputs. So here we really need to be careful and watch the discussion further, because this is the discussion paper from the authority, and it's brave that they put it out, but we need to be careful in if we apply this or not. Yeah, then as said, we have the different processing phases for AI systems. And another authority in Germany also set this within their guideline that we need to have a look at every single phase of the AI system and check these for GDPR requirements. So they said, of course, we have a collection of training data, the processing of data for the training, and then the provision of the application. So if for our use case, you are using an external provider, an AI system from an external provider, then the first 3 steps is something that probably this external AI provider is doing, because they provide you the AI system, the application of it, and have trained it before with a training data set. And for you then, the other 2 steps will be relevant is the use of the application. So to put data into the AI system and receive outputs from it. This will be the use of the application. And then, of course, the utilization of results. So the further processing with the outputs that you have received from the AI systems. And then we need to have a look at these different processing activities and check for GDPR requirements. So who is responsible for GDPR requirements? Under GDPR, we have different roles that a company can take on if they are processing personal data. So they can be a controller of the data. The controller is someone who decides independently on their own about the data processing. And this will be in the use case if you are using an AI system from a third party to analyze your analytics from your website, then you will be a controller of this personal data because you have collected it yourself on your website. Then there is the role of the processor. The processor is someone who does not decide on the processings. They only process under instruction of another party, of a controller. So in our use case, this, for example, could be the provider of the AI system, but just if they don't follow an own purpose of the processing. If, for example, they would then use your data set to train their AI system and use this trained AI system for other customers as well, then they would have an own purpose in the processing of your website visitor data, and then they will probably be a joint controller. So this is something that needs to be checked if your service provider from the AI system that you're using, what processings are they doing, and are they only acting as a processor on your instructions, or are they following their own purposes and using your data as well? And then we would need to conclude a joint controller agreement. And here it then says about who is responsible for which data and who fulfills which GDPR requirement. So for us, if we are controller, we always need to have a legal basis for the processing of the personal data. There are different legal bases that we can rely on. We have consent, contractual obligation, legal obligation, and legitimate interests. And there are currently a few challenges with legal basis when using AI systems. So what probably is a legal base that we are using if we are tracking our website visitors. We might collect consent from the website visitors to make the analytics. Then we would need to inform them about also using this data within an AI system. And so that the consent also covers this processing of putting the data set that we collected into the AI system. What is in challenge here is, that the consent is informed so that the users know what is happening, and also what happens if the user is withdrawing their consent again. Then the consequence would be that this data needs to be deleted and needs to be deleted from the AI system. And this is a struggle that we have with AI systems right now, is how can we delete data after we have put it into the AI system. And this is challenging because the AI system, if we are able to delete data, there might be a risk that the AI system is unlearning from it and is not getting better. So we need to check how we can fulfill this with consent. The next is contractual obligation. This is if we are required to do a processing activity because we have a contract with our data subject. With the website visitors, this will not apply because we don't have a contract about website analytics with our website visitors. So this is not a legal basis we can use. Same as legal obligation. This is also not something we can use because we are not legally required to do this processing. The next one is legitimate interest. This is the interest that the company has in the processing activities. And these interests must be higher than the rights and freedoms of the data subjects. So this is an individual assessment that we are doing with a processing activity. Because this is individual assessment, this has only limited legal certainty, and it is rather likely that we will need consent for our processings. Then under GDPR, we have a few data processing principles that we need to follow. We need to process lawfully, fairly, and transparent. We need to have a purpose limitation. We can only use a minimum of data set that we need to fulfill our purpose. The data needs to be accurate. It needs to have a storage limitation, so we cannot store it forever. We need to make sure the integrity and confidentiality of the data, and we need to document our the fulfillment of the GDPR requirements. With the principle of transparency, this is actually the basis for the requirement for the privacy policy, for the information obligations that we have under GDPR. So this is something, if we use our website visitors' data and put it into an AI system, this is something we need to inform our website visitors about. So we need to include this processing into our privacy policy. There are special obligations for automated decision making, but automated decision making under GDPR is only when it has a significant consequence for data subject, for example, to conclude agreements and contracts with data subjects. In our use case, this will probably not be the case, but we will have the general information obligations under GDPR. What challenges do we have here? We have the explainability of the logic of the AI and in general about the AI system, because often AI systems are kind of like a black box, and we can't really, or we don't really know why this AI system decides in which way. So this is a difficulty we have, but for the privacy policy, this is not too relevant because we, in our use case, do not need to explain the logic of the AI if we don't have automated decision making, but we only need to inform about data processing. Then under GDPR, all data subjects have different rights that they can perform. I already mentioned one, which is to withdraw consent that they have provided. But there are other data subject rights, which is the right of information to access the data so that they know exactly what kind of data is being processed from them, which is one of the most frequently asked data subject rights. And the second most frequently asked one is the deletion request, where basically the data subject asks for deletion. What we need to do is to check where within our AI system that we are using is personal data included, so that we know if data subjects perform their rights, that we know what we need to do and where we need to collect the data or delete the data, and so that we can implement mechanisms for changing data, for deleting data, or to provide a copy of data to the data subjects. And here, as mentioned before, we have challenges with performing these data subject rights within AI systems, because first of all, the definition of personal data is so broad, and it's not only names and email addresses, but it can be also interests that are connected to an ID, and identification can be made by adding further information. So this is one big challenge, and the others are about unlearning of AI systems if we delete data, if we are even able to delete data from AI systems. And then, of course, how to ensure that AI systems can be retrained after we have deleted data. Another requirement that there is for within GDPR are data protection impact assessments, which does not apply in every case. What we need to do is a risk analysis as a preparation for DPIA, where we have a look at the processing of data that we are performing, and we say what kind of risk do we have with this processing. And when we have a high risk, for example, if we are processing sensitive data like health data and so on, then we need to perform DPIA on this processing. In our use case, probably we will not fall under the requirement for DPIA, but depending on what personal data is included in the data set. And if we are required to perform a DPIA, then we make a risk assessment and see, okay, what are the risks for the data subjects and what kind of further measures can we implement to lower the risk again. So for AI system, there is not generally the requirement to perform a DPIA. The authorities have listed examples of where a DPIA is necessary. For example, here is one from a German authority who says where a call center that is using AI system to analyze the mood of the callers in the call center, that these AI systems are required to make a DPIA, but for other purposes, we need to check this. Then there are further implementation measures and requirements from GDPR, which I will not go into detail because we are almost finished time-wise. What I have with you are some measures to limit risks under GDPR. The first one is to check the AI systems that we would like to use. There are also checklists from authorities that we can use. One of these is to check if we can use the AI systems without personal data. So it might be possible that from our data set, we delete all the data that is considered as personal data and only include anonymous data into the AI system. So we don't have the challenges as that we just talked about. And another thing is then if we do process personal data within AI systems, to carry out the risk analysis and to see what kind of further measures could we implement to minimize the risk with its use. Now on the last slide, I have our top 5 to-dos for the AI deployers. So for the companies that are using AI systems, for example, from external providers. The first one is to implement an internal AI guideline for the employees that are using these AI systems so that they know how they are allowed to use the AI systems. Then it is also recommended to do an AI training for the employees in addition to the guidelines, so that they know what kind of risks there are with using AI systems and what the rough legal requirements we have. The next one then would be to perform an AI Act compliance check. So a check for each AI application that we are using to make the categorization of the risk categories so that we know if, for example, we have a high risk AI system so that we know which kind of requirements we need to fulfill under AI Act. Then for GDPR, we of course should also check what kind of requirements do we have if we process personal data with our AI system. As said, there are already checklists for us to check what kind of role do we have a legal basis to process this data, and so on. And then it is also recommended to appoint data protection officers or involve the ones that you have that you can check for GDPR requirements. And it might also make sense for bigger companies to appoint and involve AI officers who are responsible for the regulations of AI and the AI use within your company. Okay, then we have come to the end of my presentation for AI Act requirements and GDPR requirements for AI systems. Thank you very much for listening. And I'm happy to answer any questions. I will stop this presentation now, and then, Ronan, maybe we can have a look at the chat if any questions came in.
Yeah, thank you very much, Stefanie, for the great presentation. So far, there's no questions in the chat. Let's see. So for the audience, if you don't have any questions in all cases, feel free to say thank you to Stefanie. So for example, we just get Paulina just saying thank you to you. But we still have some time, so maybe I can make some questions.
Sure.
I'm going to try to loop with the presentation that I just made. So Ronan, Elo, and myself created 2 community plugins. Let's say even 3 community plugins. One is called ChatGPT AI, and the other one is Ask Your Database. So we're going to take maybe the first scenario. So the ChatGPT community plugin that we developed, so it's on the marketplace of Matomo, And on the marketplace of Matomo, it's clearly written that actually the plugins which are produced by the community are installed by the end user on their own risk, at their own risk. What this plugin is doing, it's like when you query it, it's using the API of ChatGPT and then sending, of course, the request to ChatGPT, and then ChatGPT answers. My question is the following. In this given scenario, are we responsible, let's say the plugin developer, of what we have done here if for some reason there was a prompt which was dealing with either direct personal data or either indirect personal data, let's say the visit log journey? Are we responsible for what we created as a plugin, or is the one responsible is really the one pushing the button and sending the prompt?
So this is a GDPR question about personal data. So this depends, on the GDPR roles. So we have controller and processor, and of course the person who pushes the button. The companies, who are instructing the system to make this request within the AI system, they will be a controller of this data because it's their website data. For you, it depends on if you only act on instructions and only perform this by the request of customers, or if you have own interests in the data processing. So if you are only working under instructions, then you will probably be a processor of this. And the controller is responsible for legal basis, and the processor performs the processing under the data protection agreement that they have concluded with the controller. Does this answer your question?
Actually, I'm getting lost with the terminologies, so I'm gonna turn it differently. So let's say we are producing technology which allows to talk with ChatGPT. By just creating this technology, are we responsible for any misuse of the questions which would be made through this technology, which is an AI, or are we considered, in fact, not responsible, and the one who is responsible is the one using it, not the one who developed it?
Yeah, so for GDPR, you would only be responsible if you are a controller of the data. We need to have a look at the exact setup, because this always depends on the single purposes and means of the processing. So who is deciding about the processing? For me right now, the case sounds like it that the customers who use the setup decided, and you are not deciding about the processings. But we would need to have a look at the individual setup. And for AI Act, if you are using, for example, ChatGPT, use it and create an own product with it, then you will become a provider under the AI Act, and need to check the requirements for the provider of AI systems.
Okay. Thank you, Stefanie. I'm looking at the chat again to see if we get any additional question. We got one from Paulina, but in fact you answered to it. She just wrote, in Ronan's scenario, does the developer have any obligations under the AI Act? And I think this is what you just answered. Am I correct?
Yeah, so yeah, if a developer, yeah, of course, if they create like an enterprise product with ChatGPT and sell it to customers or make it available to their customers, they will become a provider according to AI Act. Yeah.
Okay. We still have 5 minutes before the next call. I just would like to know if you have any questions that you would like me to ask you, or that you would have expect the audience to ask you today and that you didn't see.
Well, yeah, a typical question that we receive right now, because yeah, it is regarding the deadlines that there are for the implementation of AI Act requirements, are about building AI competence in the company, because this is a requirement that will affect the provider and deployer of AI systems. So the one who is providing AI systems to customers and the ones who are using them. And this does not depend on the risk classification. So a lot of customers ask us, okay, how can we do this? And here, it is important to have a look which employees are using the AI system, and categorize them into different zones. For example, employees that are only using the AI system, they need like an internal guideline on how to use it and like a basic training maybe of it. But if we, for example, have employees who are developing AI systems, they need a much deeper training on AI regulation, to understand what are the risks and what kind of requirements do we have, and also the management, the people deciding on the use of systems and processing, they also need knowledge about risks of AI, so that they can make their decisions based on a risk-based approach. Yeah, so this is often a question that we receive here.
Okay. Thank you, Stefanie. I'm looking at once more in the chat. We do not have any questions left, and in 3 minutes we are getting the next speaker. Once more, I really would like to say thank you, Stefanie, for being part of MetMoCamp 2024 and for your great presentation, so as the quality of the slides. Thank you.
Yeah, thank you for having me, Ronan.